Hi, Tony again from Estate Planning Solutions with another video. As I said in the last video, we're going to do a case study. This is an interesting one. It was settled in the Supreme Court in earlier in 2015. It's called Munro versus Munro, and Google it, download it, read it. But at the end of the day, here's what happened. We had a busy lawyer who had been in a broken relationship, and his accountant, who also was a financial planner, rang him in 2009 and said, look, you're in a different relationship now, so let's set up your affairs so that they're pretty tight and you can send the money where you want it to go without any problem. So the lawyer, he actually drafted the document and put it in place. Anyway, as time goes on, he passed away, and the bulk of his money was in a self-managed superannuation fund. Now, he and his new wife were trustees of the self-managed super fund, and basically the proceeds were to go to his kids and his ex-wife, and some money to his new wife. So as it turned out, he passes away, and the rules are really simple. I mean, if somebody is a co-trustee of a self-managed super fund and one of them passes away, a new one's got to be appointed. So the second wife decides to appoint her grown-up daughter as a joint trustee. And anyway, the next step that happens is they write to the beneficiary's lawyer and advise them that the binding death benefit nomination, which was set up by the accountant and the lawyer, bearing in mind the accountant was a financial planner as well, is defective, and that the money's no longer going to where he wished. In fact, it's going to her and her family. So the daughters of the deceased mounted an action, and when it all came to fruition, lost. So the new wife and her family benefited from his superannuation. So really, at the end of the day, what are we looking at here? We're looking at the fact that the second wife obviously had some very sophisticated advice. Did she always intend to get her paws on his money? We got another family ripped apart by a dispute with wills and estate planning. And the overriding issue out of all this, besides the distress and the lawyer's fees and the fact that this man's money didn't go where he wanted to go, and he was a lawyer and his accountant was a planner, is this one. Is that your associated lawyers, accountants and financial planners should not be dabbling in this area if they're not fully familiar with it. Again, as I said in video number 1, this is about trust versus competence. So you can trust them, great, but are they competent? So it's time, people, for you to start digging, asking questions, looking at your own affairs to make sure that the money goes where you want it to go.